Hello everyone, welcome back to Legal Prudent Study channel. Today in the series of legal update, the topic is right to appeal against conviction. So why it is in news? Recently, in the case Mahesh Singh Banjara versus State of Madhya Pradesh, the Honorable Supreme Court noted that right to appeal against a conviction is a statutory right provided to accused by the virtue of section 374 of the CRPC, that is Code of Criminal Procedure. Now it is mentioned in section 415 of Bharatiya Nagar Sanction Sanhita. The marginal head is appeals from conviction. So what is the background of this case? An appeal was filed against the Madhya Pradesh High Court decision which had dismissed the appellant's challenge to his conviction due to a delay of 1637 days in filing the appeal. The appellant had submitted an application to excuse the delay along with his appeal, attributing the delay to financial constraints and the need to travel out of town for work. The High Court interpreted these reasons as indicating that the appellant had absconded the following judgment, leading them to reject the request to excuse the delay and uphold the original sentence. Discontent with the High Court's decision, the appellant sought relief from the Supreme Court, the Honorable Supreme Court. The court observations. The bench of Justice V.V. Raghunatha and Justice N. Koteshwar Singh overturned the High Court's decision, which had dismissed an appeal due to a lengthy delay without fully considering the reasons for it. The Honorable Court emphasized that the right to appeal, especially when it affects an individual's liberty, is a fundamental right under Article 21 of the Constitution. So, in generally, we can say right to appeal is a statutory right, but when right to appeal, especially when it is affects an individual's liberty, then it amounts to fundamental rights under Article 21 of the Constitution of India. Citing precedents, the Supreme Court allowed the appeal, condoned the delay, and directed the High Court to reassess the case on its merit. So, right to appeal against conviction at a glance. It is a statutory right granted to the accused. Okay, Article 21 of the Indian Constitution and Section 374 now. Section 415 of BNSS. Article 21 of the Indian Constitution and Section 374 of CRPC, now 415 BNSS, unequivocally granting the right to appeal. Right to appeal from a judgment of conviction affecting the liberty of a person, keeping in view expansive definition of the Article 21, also a fundamental rights. Section 374 of Code of Criminal Procedure deals with the appeals related to the conviction. Now it has been mentioned under the Section 415 of Bharatiya Nagar Sanction Sanhita 2023. The another case law on right to appeal against conviction, Dilip S. Duhanukur versus Kotak Mahindra Company Limited and another 2006. In this case, it was held that an individual convicted of a crime has the fundamental rights to appeal under Section 374 of the CRPC, given the broad protection of liberty under Article 21. This right to appeal against a conviction is unconditional and cannot be limited by any condition. So let's practice a question on this topic. Which of the following statement is true regarding the right to appeal against conviction? Your option is: it is a privilege that can be granted or denied by the court. Second, it is an unconditional fundamental rights under Article 21, only applies to civil cases, can be exercised only with special permission from the Supreme Court. Write your answer in the comment box. Thank you for watching. Please like, subscribe and share.